Good afternoon. We have one case scheduled for argument this afternoon, the case of Hollingshead Materials, LLC versus Yellow Tag Auctions, LLC, et al. Is counsel ready to proceed?
Yes, Your Honor.
You may approach counsel.
Thank you.
Counsel have allocated 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, I would, Your Honor.
So noted. You may continue, counsel.
Thank you. May it please the court, my name is Ben Pendroff. I'm a partner with the law firm of Barnes & Thornburg, and I'm here on behalf of Appellant Hollingshead Materials, LLC, to ask the court to reverse the trial court's order granting a writ of prejudgment replevin for a number of reasons. As an initial matter, replevin should be inapplicable. The money damages would be sufficient if Yellow Tag were to prevail at trial, as my partner, Mr. Folland, noted to the trial court during argument. The writ of replevin should also be reversed because there was no competent evidence supporting issuance of the writ. It is plaintiff's burden, that is Yellow Tag's burden, to show that it is entitled to possession of the property at issue, and they did not meet that burden with competent evidence. In fact, there was very little evidence presented, mostly in the form of affidavits, and the court seems to have also taken into evidence the argument of counsel, which is inappropriate. There was no evidence.
Counsel, you're not arguing that doing it on affidavits was improper. That was, okay. I mean,
Yes, doing it
nobody
on
said
affidavits
stop,
is
we need
improper.
testimony. Okay.
Yes, correct. However, the affidavits did not establish evidence which would defeat Hollingshead's superior right to the property at issue. Further, a prejudgment writ of replevin, according to the replevin statute, requires a finding that the property at issue would be removed or destroyed or concealed or otherwise kept away from the party that's pursuing it. There was no evidence of that in the affidavits, and in fact there is no finding of such in the order, and on that basis alone the order should be deemed facially deficient and reversed for that reason alone. I would note that argument was not in our appellate brief, but I did want to point that out for the court. So the reason that the trial court appears to have granted the writ of replevin was because the trial court determined that the contract at issue, and the contract at issue is one to which Yellow Tag is a stranger. The contract at issue is a services, a demolition contract, entered into between Hollingshead and Total Wrecking Environmental. It's a contract pursuant to which Hollingshead hired Total Wrecking to come into a plant that was purchased by Hollingshead and do demolition work, regulatory work, abatement work, and as consideration, Hollingshead said, whatever scrap metal you find, you get to keep. Now, there was some payment going from Total Wrecking to Hollingshead because they knew that the value of the scrap metal could exceed the value of the work, and so in order to be fair, the consideration had to be as such. But this is a services contract, and how do we know that? Well, the court looked at the predominant purpose test, and I think the parties both agree on how to apply the predominant purpose test. In Florida, the predominant purpose test looks at a hybrid contract, one that could be for both goods and services, and tries to determine which is predominant, the goods or the services. Now, with any contract, the first thing we look at is the contractual language. And if we look at the introduction to the agreement, we see right there that it is a contract for services. If the court would look at our amended appendix at page 54, it says this agreement is made between Total Wrecking Environmental, defined as contractor, and Hollingshead Materials, defined as owner, for work to be performed by contractor. Now, under Florida law, a contractor provides services. A contractor is not a merchant. And so the case law teaches us that these words have import. Both parties cited BMC Industries versus Barth Industries, that's 160 F3rd 1322, which discusses the import of analyzing the words in the contract. Now there, the court did decide that it was a contract for goods, but that's because in that case, in the BMC case, the parties referred to themselves as buyer and seller. There were purchase orders, there were indicia of a sale of goods. Here, we have owner and contractor, and as I said, under Florida law, a contractor is a service provider. That's In Re Sunshine Junior Stores Inc. 240 BR 788. So that's the first indicia showing that it is a contract for services.
A lot
Council,
of,
let me
yes.
ask you a question. Would it make a difference to your analysis if the money went the other way?
Well, so if the money were going the other way, it would be Hollingshead paying for these services. It would depend on what the consideration was there. If there were no scrap metal involved and we just went out and hired Total Wrecking to do the demolition and we paid them, clearly services. Here, the consideration just worked a little bit differently, but the framework, the scope of the contract is for services, not for the sale of goods.
But you just, I think, push the panic button here because, or the key button here because there are goods involved. You know, you said if it weren't a contract for something, you know, taken out, or if the contract had been written differently. But the bottom line is they are taking stuff out of the property, right?
Yes,
Physical stuff they're taking out. So why is that not a pretty much controlling fact?
because they're taking the stuff as their consideration, right? It is not that they are paying for those goods. They are taking that as consideration for the work that they are doing. And so it's still a services contract, and we see that as we look through the contract.
So, Counsel, is your
Yes.
position that they are not paying for the scrap metal?
So they are paying for the scrap metal in a sense. What they're doing is they're getting paid in scrap metal. They are doing the services and getting paid in scrap metal, but because of the value of the scrap metal, they are paying back to Hollingshead some of the value of that scrap metal.
But you don't disagree that the scrap metal is in fact goods?
I would not disagree that scrap metal in and of itself are goods, but they are not goods that were identified at the beginning of the contract because, and this is why it shows us that this is a services contract, without the demolition, there is no scrap metal. It's not that they just went on and said, okay, whatever we find around here, we get to take and we're gonna pay you for it. It's, we're going to do this work. And after we've done this work, which they did not complete, and they were in default, but after we do this work, you're going to pay us by giving us those goods. So it is not a contract for the goods are the consideration. And
But
so-
then is it your position that the scrap metal that had been removed from the facility was wrongly taken because ownership had not transferred to Total Wrecking?
It's not that it was wrongfully taken, it's that I don't believe that title had passed as of yet because they were in default. And to the extent that title had passed, it was for anything that was allowed to be taken. The property at issue here was not permitted to be taken because of the default by Total Wrecking. And there's no evidence that Total Wrecking was not in default. There's no evidence that Total Wrecking was able to take this stuff when Hollingshead said that it couldn't. The trial court.
what's the metal that was allowed to be taken, and how do you draw that line?
So I'm not able to speak specifically to what was taken. I can say that throughout the course of the work that they were doing, they were removing some scrap metal, and to the extent that that was taken, you know, that's not what's at issue.
Well, you use the phrase allowed to be taken. So where are you pulling that authority from in these contracts, and how are we supposed to draw that line that you're drawing?
So that's a fair point. Thank you for that. I probably shouldn't say allowed to be taken. They were doing the work, and they took those goods. But those goods are not the ones that are at issue, right? They defaulted on their contract. They did not pay as they were supposed to, and we told them, stop doing what you're doing, and did not allow any further goods to be taken off the property, or no, we stopped them from taking any further goods off of the property.
But did Total Wrecking and Yellow Tag remove scrap metals, including equipment, only from those areas of appellant's facilities that Total Wrecking had finished demolishing?
I'm not sure of that, Your Honor. What I can say is that any scrap metal that they were supposed to take was supposed to be derived from the work. So it should have been the case, I just can't speak authoritatively on it. It should have been the case that any scrap metals would have been a byproduct of the work that they did. Because as the contract says, they can take the scrap metals must be derived from the work described in detail in Article 4. And Article 4 of the agreement is a long list of things that Total Wrecking needed to do, all of the services that they needed to provide. It's demolition, it's abatement, it's regulatory work, it's permits, it's insurance. And I think one of the key parts of this contract that shows that it is a services contract and not a sale for goods is Article 5. If we look at page 56 of our appendix, pursuant to the contract, Total Wrecking had to get a performance bond of $5 million to assure that they were going to do the work. That's the point. The work is the point. And that's why they had to get a $5 million bond. You wouldn't see something like this, I assume, in a contract for goods. And so in the cases that Yellow Tag has cited in its brief, those cases are inapposite. Those cases deal with purchase orders. Those cases deal with buyers and sellers. That's not this case. Here, we just have services.
So they have a $4 million initial deposit, right?
Yes.
And the bond is $5 million, so shouldn't we just add them up and reach the $9 million for the scrap metal value? I mean, shouldn't we look at the bond as just further security for the goods that are being transferred to Total Wrecking?
Well, it's security to make sure that they're going to complete the job, and that if they're not going to complete the job, they have to make sure that somebody else is going to come in and complete the job, and that's what has to happen now, is someone else has to come in and complete the job. So it's not a case of a purchaser going out to someone and saying, I'd like to buy your scrap metal. It was Hollingshead that said, we need this demolition work done. And so we're going out and we're going to find someone who does demolition work. And one of the things that the BMC court says to look at is the nature of the supplier. Now, here I believe that the supplier would be Total Wrecking, and Total Wrecking, as the name implies, is a wrecking company. It is not a company that buys goods and sells them. If you're talking about the nature of Hollingshead, then we make concrete. We don't make scrap metal, and we weren't selling concrete. And so when we look at the contract holistically, what was the overall purpose? The purpose was the demolition, the abatement, and all the work described in the scope of work.
When we're looking at this, predominant test, do you have any case where a court has determined that something is a services contract where the service provider has to pay the service recipient?
I'm not aware of a case that says that, and admittedly, this is a somewhat different circumstance. But that's the way that the consideration was agreed upon between the parties. It was, you do the work, you get to keep whatever's left there. It's not, come on and we're going to sell you this product.
Regarding the predominant test, the trial court relied on section 672.4013B Florida statutes to conclude that title to the scrap metals likely passed from appellant to Total Wrecking at the time they executed the agreement. Now, that section provides in part that if the goods are at the time of contracting already identified and no documents of title are to be delivered, title passes at the time and place of contracting. How do you reconcile that provision with your argument?
So there's a couple of things there. First of all, in applying that provision, the trial court assumes that the UCC applies, and our position is that it doesn't. And if the UCC does not apply, then that provision has no relevance. But in any event, the contract says, the contract speaks to title in sections 3.1 and 3.2 when it talks about the consideration, and says that in consideration for the work that you're doing, you will get the scrap metal derived from the work. But they have to do the work first, and they have to pay the money first, or else they're not getting the scrap metal. And scrap metal here in the contract is defined very, very broadly. The individual pieces of scrap metal were not identified at the time of contracting. They had to be, again, derived from the work. So I think that the trial court there, A, was assuming that the UCC applies when it doesn't, and B, was not recognizing that the parties had contracted to determine when title would pass.
So you just paraphrased, I believe, Article 3.2, that this notion that, okay, in consideration of the work, then owner agrees to transfer ownership of scrap metals.
Yes.
And is that the provision you're relying on for this condition precedent argument? That, okay, you, Total Wrecking, have to complete your payments and services, and then ownership will transfer to the scrap metals?
If the court were to agree that the UCC applies, then yes, but I don't think we even need to get there because the UCC does not apply, and therefore the order on the prejudgment writ should be reversed because it's completely based on the UCC's, on the application of the UCC to the facts.
So if the UCC doesn't apply, then what provision in this contract tells us who owns the scrap metal?
When we would point to 3.1 and 3.2.
In 3.2 and 3.1, aren't they just mirror images of each other? So, I mean, depending on which one you read, you could make the argument, okay, the condition precedent belongs to this party rather than this party, and then just vice versa?
I understand the reading, I understand that reading. It's our position that they have to do the work to get the scrap metal. And it's like any other contract that if you contract to do something, if you don't do it, you don't get the benefit of that contract.
Yeah. And I mean, this phrase, for and in consideration of, I mean, this phrase appears in almost every contract. And so are you asking the court to read into that phrase a condition precedent or some sort of timing aspect of when these promises are performed?
Again, to the extent that the UCC, to the extent that the court would apply the UCC, we think that, yes, this would abrogate the notion that title passes at the time of contract, and to the extent the court is not applying the UCC, we think that this shows that title passes after performance of the work.
Did the contract define scrap metal?
It defines scrap metals as all ferrous and non-ferrous metals at the facility in areas of the work as of a certain inspection, including equipment and reuse of metals to be sold by contractor for scrap.
Let me ask you a question. I know we're eating into your time, and if necessary, we can expand your time, but
That's fine.
all the goods, or you don't like that word, but the stuff that they're taking out, let's run the tape backwards. When that was going into the mill, were they goods? Were there UCC ones? Would they have been considered goods?
I suppose in their component parts, yes, because whoever built the buildings at the time, which was not us, would have had to purchase those parts.
Right, and if they were goods going in, why aren't they goods going out?
So it's not necessarily that the materials in and of themselves are not necessarily goods. It's that whether or not they're goods is ancillary to the purpose of the contract. And the purpose of the contract is for the work provided by Total Wrecking. The goods are their compensation. So a rose by any other name, it's still a good. But really, that's not the issue here. The issue is that the trial court said, basically, because they're goods, this must be governed by the UCC, and then failed to look at the contract as a whole and the purpose of the contract, including the the names that everybody gave themselves, the fact that there was a performance bond, the scope of the work, and just hung its hat on, I think these are goods, therefore the UCC applies. And because the UCC does not apply, the writ of replevin should be reversed.
Is there any evidence in this record that the cost of the goods did not exceed the value of the services?
There's not evidence in the record specific to the cost of goods, but there's also no evidence in the record specific to the cost of services. It's a lump sum that says for these services, you're going to be getting these goods, and this is the price of payment.
You have 1 minute and 29 seconds left for rebuttal. How about we extend that time by an additional 3 minutes?
Well, unless the panel has any other questions, I'll reserve the rest of my time for rebuttal.
Thank you, counsel.
Thank you.
Good afternoon, may it please the court. My name is Julia Madalena. I'm an attorney with DMW Law Group here in Bay County. First, welcome to Bay County. We're very glad to have you. I represent Yellow Tag Auctions in this matter. We are defending Judge Goodman's order granting a writ of replevin. Now this is pre-final hearing, and I think that's important that we acknowledge our procedural posture as we work through these issues. This is governed by section 78065 Florida statutes, and that requires a judge to examine a complaint when it's filed for replevin and determine if it meets a prima facie case to issue an order to show cause. And at the order to show cause hearing, the court will then accept evidence in the form of affidavits, or it can be testimony, and the court is tasked with deciding, based on what's before it, who with reasonable probability is entitled to possession of the property pending a final hearing.
And what did the court have before it to make that determination?
Yes, Your Honor. So the court had a few important pieces of evidence. We had 2 affidavits submitted by my client from contractors or employees of my client on site actively removing equipment from the paper mill for over 3 months before they were ejected from the property. Those affidavits confirmed that Hollingshead knew we were there, that Hollingshead even offered to buy back equipment that was being transferred as part of this sale, acknowledging that they understood that these were goods that had already been downstream in the sale of commerce. They also, when they refused my client further access to the property, the affidavits showed that a truck was fully loaded and ready to exit the gate. They forced them to turn around and unload that truck.
Had Hollingshead been accepting money from the contract? Had they been receiving money?
So this is an unusual situation where you have the paper mill owner who enters into a contract with Total Wrecking, who then sells equipment downstream to my company, which is an auction company that sells industrial equipment. So we did not have a direct contract with the property owner, so our funds did not flow directly to Hollingshead. However, in the primary contract, $4 million in a down payment was made, and that's undisputed and in the record, that was submitted. There were then supposed to be periodic installment payments made. Now, I think that's important, and I'll pause here just to emphasize that those payments were not contingent upon demolition. That money was flowing from Total Wrecking to the property owner. That was for goods. That was for property. That was a sale of property. And in fact, if we look at the cross-claim, the allegations that Hollingshead has made in numerous places were that Total Wrecking never got permits for demolition. They never got the asbestos abated, yet they were on the property removing equipment and materials, goods, right? And that can be found in the record.
Counsel, what was Total Reckon's position in regards to the contract?
Total Wrecking's counsel has no objection to our request. They also stated to Judge Goodman at the hearing that they believed it to be a contract for the sale of goods. Admittedly, that's a legal opinion by an attorney. I think the judge was tasked with formulating his own conclusions based on the evidence in front of him and the legal standards. But the court also had the contracts, right? And those are crucial because the predominant purpose test tells us we've got to look at a few things. The contract language, the billables, right? Is it services, is it goods, is it broken out? Who's paying for what, and what is that in terms of proportion? And then are the goods movable and identified? And I've heard argument that these goods were not identified. There is no case law cited for you, and I don't think you'll find any saying that there has to be an itemized list where each piece of property is specifically laid out. Now,
But do the terms of the Hollingshead Total Wrecking Agreement address when ownership of the scrap metals transfers to Total Wrecking?
it does not, Your Honor. We disagree strenuously that Article 3, titled Consideration, does anything more than simply repeat an inverse of I will give you this if you give me that, and the inverse. Now, we have cited in our filings, Your Honor, some examples where language was found sufficient to talk about when title passed, and that can be found on pages 92 and 93 of the record, and I can quote some of that for you. And so an example from the case law, this is a case out of Louisiana applying an Alabama statute, but because this is the UCC, it is uniform across jurisdictions, so case law from around the country is illustrative. But quote, I'm sorry, this is Southwest Bank of Omaha versus Moritz, I apologize. But the quote is, at the time the goods were identified, they consisted of fixtures and inventory then located in the store. No physical delivery need to be made. The contract did not contemplate delivery of any documented title. Title passed at the time of contracting, and we go on in our brief to talk about the language that can be found. And I apologize, I'm trying to find the quote here. Excuse me, it's on page 100 of the record. So St. Paul Fire, which is actually a first DCA court, examined a contract and said that it must be explicit when it refers to title. There's also a case, Suburbia Federal Savings. This is a fourth DCA case. And in this case, they did find that the contract touched on the issue of title when it contained the following language. It is expressly understood and agreed that title to the above described property is retained by Bell Air Conditioning Company, Inc., and same shall not pass or become vested in the purchaser until the entire purchase price has been paid. And it goes on beyond that to elaborate that. So that's the type of explicit language that we would be looking for in this contract if we were to determine that title was reserved in the contract in terms of when it would pass. Now the UCC tells us if it is not in the contract, then we revert to the default rules. And the default rules, which is 672.401, tell us that we look at delivery. And it has a few different options, right? Delivery can be sent from the seller to the buyer. You can put it into transit. You can actually deliver it to their premises, or the seller can pick it up from your premises. That's exactly what we have here. This property was kept at the paper mill. The contracts, both contracts, contemplated that these buyers are going to come, they were going to then remove the property, and the UCC tells us in that case, unequivocally, title passes upon signing the contract.
Yeah, counsel, the trial court properly examined the movability of the goods in applying the predominant test.
I believe the court did, Your Honor. I would first notate that the first argument about whether these goods were movable was made in the appeal brief, in the initial brief in this case, and we did respond to that, arguing that that had been waived by not being fully addressed and raised below. Now, movability is still an element of the predominant purpose test, so Judge Goodman would need to make that decision. Movability, I think, is evidenced by the contract in this case. It contemplates that goods are going to be removed and sold in the stream of commerce while the work, the demolition work, is ongoing. It also speaks to things like equipment, and I'll go to the contract itself to give you the best evidence of its language. This is in Article 4, Scope of Work, Sub K, and there's a list of places that are not included in the contract, and then the following paragraph talks about what is included, and it talks about buildings and structures being included, but then it also says paper, machine building interior, generator building interior, water treatment area structures, wood yard crane and equipment, other piping and equipment, cooling towers and all tanks, equipment, piping, boilers, powers, wiring, and cables will be demolished or salvaged as part of the contractor's scope of work. And I think that within that list, we see several items that would clearly qualify as a movable good and are being identified in this contract. We also know that the parties contemplated that this would occur during the course of performance, and did in fact occur during performance. When we look at the damages provision that they have in their contract, they have a default section. This is 13.3, and it says that in the event of a default, damages are going to be calculated by taking into account the work performed up to the date of termination, and then it says contractor shall provide a detailed accounting of all profits realized from the sale of materials removed from the facility, which shall be considered to ensure fairness to both parties.
On that damages provision, and you're looking at Article 13.3, right?
Yes.
How are we supposed to interpret that language in accordance with your position that title to the scrap metal, you know, is basically transferred at the very time of contracting? When 13.3 seems to indicate, okay, there's sort of a movement of title with the product.
I think, Your Honor, that's not explicit, which is what the UCC requires in order to reserve title. And so when we look at the contract language, we're first saying, is it a contract for the sale of goods? And then is there an explicit provision touching on when title passes? So even if it's an inferable or reasonable possibility that this damages calculation might infer that title would remain, it's just not clearly stated. And so we have those default rules that apply.
So let's take those default rules step by step, right? Okay, so the initial agreement between Total Wrecking and Hollingshead, is it your position that title to all of the scrap metal on the property under this agreement transferred at the moment of contracting?
I think title to the goods transferred at the moment of contracting, and that would have occurred, I believe it was in June of 2024. My client's contract was in October of 2024, so Total Wrecking would have had title, and then when they signed the contract with my client, which does have an enumerated list, it's a subcategory of those, but it's equipment like transformers and large electrical components, that title transferred at that point as well.
Okay, so playing this out, if title to all of the scrap metal belongs to Total Wrecking, then is it your position that the termination by Hollingshead really does not affect any of the title of any of the scrap metal?
Absolutely, and we've been consistent in that position. I think talking about who breached, which has been argued both ways, and really involves a contract and two parties separate and apart from mine, is really a red herring. It does not impact the ownership of the property. Now, what is a way in which Hollingshead could have protected itself? It could have retained a security interest. That's what one does when you sell goods. So if you want the ability to claim those back and not just have a claim for money damages. And so these parties do have competing claims for money damages against them. We don't take a position as to who breached, but we don't think it impacts the outcome of this particular replevin.
So when you read the last portion of Article 13.3, when it says, look, give an accounting of all profits realized from the sale, is it your position that Total Wrecking can still basically extract all the scrap metals and continue to make profits even after they've breached and Hollingshead is terminated?
I think that's correct, and you'll actually see the inverse of this situation in a case we've cited, and we cited it both at the lower court level in our briefs, and I apologize, I don't have the site with me, but one of the parties is BR111. It's an extremely long title from a federal case, but it was actually inverse, right? So a seller had sold goods downstream in commerce. They had an installment contract. There were payments to be made, and they sought replevin. They said, well, you didn't make your payments, and the court said, too bad. You don't have a security interest. It's theirs now, and they can do whatever they want with it. Now they may still owe you money. And when we look at the contract, it has the formula for how the payments will be made, the draw schedule. And so I think you can also interpret that damages provision, that formula, to talk about if the work is done and the stuff is gone, but the payment schedule still continues, right? I mean, there's different scenarios in terms of how this plays out. So I don't think we can assume that a termination would only include a situation where goods still remained on the property.
Did the contract in question have a reservation clause, reservation of title until all performance has been done?
No, Your Honor. Not an explicit one, not something required by the UCC. And I would add, in regards to the UCC, because I think this is particularly important, Section 671.102 sub 1 Florida statutes says essentially that the UCC should be interpreted liberally and construed as applied. And the case law has told us, including the Wadley case we cited from the 11th Circuit from 2022, essentially in the event of a tie, if you're not sure when you run this test, it goes in favor of the application of the UCC. And the Wadley case is a great case to look at. That involved a granite plant. Here we have a paper mill. In that case, they were constructing the granite plant, right? Here we're disassembling the paper mill. But it's very similar in terms of how the court looked at, well, if you're building a granite plant, you're designing, you're engineering, you're installing. Is that a contract for services? And the court ultimately concluded, no, it was for goods. It was for goods. And here we simply have the opposite. We have a mill that was there that is being disassembled, but those goods are flowing back into commerce.
I mean, in the Wadley case too, you had the service provider providing the goods too. So sort of the goods and the services were coming from the same company. How does this notion where, okay, the service provider is not actually providing any goods either in this case?
Yes, Your Honor. So I think that goes back to looking at the proportionality of this situation, right? So yes, Total Wrecking is providing services. There is no question this is a mixed contract and that the predominant purpose test applies. But then when we look at what was actually going on here, right? We look at the contract language, we understand the situation, and we understand you do not normally hire someone to demo your home and they pay you, right? In this situation, Hollingshead hired Total Wrecking, yes, to demolish some buildings, but in the process, there was a walkthrough, that's evidenced in the contract. It talks about a site visit where bids were placed, and the bid, and the ultimate winning bid, was that Total Wrecking was gonna pay $9 million for the privilege of coming onto the property and taking those buildings down. And that really, I think, tips the scales in this case. I do believe, and Judge Goodman had asked, if the numbers were different, right? If the ratios were different, would it be a different outcome? And I would say, yes, I think that's quite possible, right? If it was 50-50. But this is a situation where the value of the goods is $9 million more, at least, than what the services are that are being provided. That's what makes it economically feasible for Total Wrecking to come in and then perform the work, make its own profit, and return those goods to the stream of commerce. And I think it's important to acknowledge as well that, and I think it's undisputed, Hollingshead, and I think I heard counsel say it, they're a concrete company, they're not a paper mill. They bought the paper mill to transform it into something that they could use. They are liquidating old equipment and supplies, recouping as much profit as they can get from that, and yes, clearing the land so that they can use it for their own purpose. But that is incidental to the overarching effect of this contract, and I think the intent of the parties based on the realities of the situation.
Would it make a difference if Hollingshead was moving the goods as opposed to Total Wrecking?
Yes, that would. The UCC tells us that if the seller of the goods puts them into transit, title passes when they go into transit. If the seller is actually delivering them, then title transfers when it's actually delivered. But there's no question that in both of these contracts, the folks were coming on site to the plant. They were in charge, full scale, of gathering that, putting it onto rail cars, putting it onto trucks, and moving it out.
As we're sort of reviewing, contract interpretation de novo, one fact I want sort of your confirmation on is the timing of the sales agreement between Total Wrecking and Yellow Tag versus the termination between Hollingshead and Total Wrecking. What was the timing of those two events?
So and you can also see in the cross claim, which is allegations, those are not sworn evidence, but they are the representations of Hollingshead. But the chronology was in June of 2024, the initial contract is executed between Hollingshead, the property owner, and Total Wrecking. My client then signs a contract in October of 2024 to purchase a subset of those goods, specifically industrial electrical equipment. They then come on site, this is evidenced by our affidavits. My client comes on site with folks that they've employed to begin removing that. And again, when you're talking about industrial equipment, it can be a time-consuming process to get some of these very large things out and onto rail cars and things of that nature. So from October then to December is when that occurred, and in December is when they locked them out of the property, and that is also supported by our affidavits.
Counsel, would we have to reverse the trial court's order if we determine that the UCC does not apply? Please explain.
I think that is correct. It is fundamental to our position that the UCC does apply. I think if the UCC does not apply, then we are left with common law rules. That was not briefed to the trial judge. There was not really evidence put on for the trial judge in that regard. So I think the answer is yes. Now, do I believe Judge Goodman got this correct based on the facts and the law? I certainly do. I also believe that at this early procedural posture, where this is reasonable probability, right? Reasonable probability, with a presumption that the UCC applies in the event of any sort of tie or uncertainty, that he did make the right choice. Now, we also know, and it is in the record, that Hollingshead posted a $500,000 bond. The property remains with Hollingshead. So we're here, and other than lots of legal battles, not much has changed on the ground, I'm afraid, but that is where we are in the world today.
Well, your client is not able to fulfill the downstream contracts that they have, correct? Because
That's correct, and that was certainly an issue and a time-sensitive one when we were dealing with this early on in the case. And when you look at the timing of the pleadings and the order to show cause, that happens very quickly. I mean, the judge reviews the complaint, he sets a hearing within a month. There is no formal discovery. There's not a lot of opportunity between that point and this hearing. And so the parties present the best case they can. We did advocate to the judge, and it was discussed that we had contracts downstream. You know, but the law does allow them to post a bond and retain possession. So that's where things ended up.
Can you speak more to the common law rules and why reversal is required if the UCC does not apply?
Well, I would say this in terms of the common law rules. I think, and based on my research when I was looking into this, you know, number one, I became fully convinced that the UCC does apply. But number two, I think the common law rules are not so clear, and it's more ambiguous in looking at the contract in terms of when the title would have passed. So I do believe, based on that, the allegations of breach, you know, we did not have a mini trial on who breached and when, and so I think because of that, I'm not necessarily conceding that the common law would result in my client not having ownership of that property, but from a factual and evidentiary perspective, I just don't think that the records would sustain that as an alternate perspective.
Thank you, counsel.
Okay, thank you so much.
Just a few points in rebuttal. First, I want to apologize for my coughing and appreciate the gentleman behind me who gave me some water for my dry throat. And to the question of whether reversal is required if the UCC doesn't apply, I appreciate my colleague's candor with the panel. I think that's exactly right. Because of the evidence that was considered by the court, the entire decision was based on the erroneous finding that the UCC does apply. And so Yellow Tag made two arguments. UCC applies, and so title transferred at execution, and if not, we're a purchaser under the UCC. So based on the evidence in the record, if this panel finds that the UCC does not apply, it would mandate reversal. My colleague also raised some default provisions of the UCC. Again, we don't believe it applies, but it was noted that title would pass when the seller comes to pick up the goods. It's worth remembering again that Yellow Tag is a stranger to the contract. They are not in privity with Total Wrecking and Hollingshead as to that contract. Obviously, they have privity with respect to their own contract with Total Wrecking, but they have no privity when it comes to the demolition and services contract. My colleague also noted that, or I believe it was Judge Treadwell who noted that Yellow Tag was not able to fulfill its downstream obligations at this point. As Yellow Tag has said, they're an auctioneering firm. They get the stuff, they sell it. There's an easy remedy here, and it's monetary damages if Yellow Tag were to prevail at trial. And that's why I said at the beginning, we don't believe that replevin is even appropriate here, and this is not what the replevin statute was meant to address. And so, finally, I'll leave it with something that I said at the beginning. I always say I hate to be overly technical, but my Civ Pro professor said, we're lawyers, technical is what we do. In order to grant the writ of replevin, there had to be a finding that there was danger of the property being moved, destroyed, concealed, or otherwise made unavailable to Yellow Tag, and there was no such finding. And so, on that basis, and the fact that the contract is one for services and not for goods, the writ of replevin and the order granting it should be reversed.
Thank you, counsel.
Thank you.